At this time, I would like to introduce our presenter, Megan Boleyn. Megan is a program manager at Self-Determination Housing of Pennsylvania. She has over 15 years' experience managing nonprofit housing and legal assistance programs serving seniors and individuals with disabilities in Delaware and Pennsylvania. Prior to joining SDHP, Megan worked for the Housing Equality Center of Pennsylvania, where she managed fair housing compliance investigations, educational outreach initiatives, and technical assistance programs for communities, housing providers, and nonprofit partners. Since 2005, she has conducted hundreds of fair housing trainings for landlords, housing programs, government officials, and consumers. SDHP is a statewide nonprofit that works to expand housing opportunities for people with disabilities in Pennsylvania. SDHP provides training, technical assistance, and information on housing issues impacting people with disabilities and works closely with local, regional, and state partners to design and promote policies, programs, and initiatives that increase the stock of affordable housing. And with that, Megan, I pass it over to you.
Thank you very much for that warm welcome. Welcome to everybody who is joining us on the call and on the web. I second the. I do think if you are just calling in, make sure that you go ahead and log in so you can get access to the presentation, which everyone will be receiving afterwards. Really quickly, I have a lot of great information to share with you today. So I want to start off by saying that we're not going to get to everything. We're going to get to a lot. And just so you have an understanding, reasonable accommodations and fair housing in general, you could have weeks and months of training devoted just to this. So we're going to attempt very quickly to just skim the surface of accommodations and housing, make sure that you go away today with an understanding of the basics and where to go when you identify these issues occurring. So with that in mind, I'm going to go ahead and get things started and let you know that really what we're going to cover, the fair housing laws, rules, and regulations, protections specifically for people with disabilities. That is our focus today. That's the focus of the work my organization, Self-Determination Housing of Pennsylvania, does. And one of the highlighting protections of the Fair Housing Act are accommodations in housing for persons with disabilities. So we'll kind of explain what that is, what it looks like. I'll provide some example accommodations so you can think how this might come up within each of your communities. And I'm not going to leave you today without making sure that you have directions and where to go to get resources and assistance in Pennsylvania. I do want to also very quickly clarify at the start of today's program that I am not an attorney. Nothing within this presentation is certainly going to constitute legal advice. But I do recommend that whenever you're kind of looking at these matters, it does require a fairly careful analysis of the facts, the case law that applies, the rules and regulations. It can get very technical, very quick. So if you are looking into any of these matters, I do recommend that you consult with somebody who has a good familiarity and understanding of fair housing laws. That being said, let's go ahead and kick off today's program because we do have a lot to cover. In terms of the issue of housing discrimination, I want to very quickly just show you, how discrimination exists within our communities. HUD estimates that there's 2 million instances of housing discrimination occurring each year. However, fewer than 1% is really reported. So a key piece of fair housing education is, one, identifying if discrimination is occurring, but also making sure that people report it so that discrimination does stop. In 2017, the top bases of discrimination were disability at 57%, race 19%, and then familial status. And we'll talk about these protected classes, but you'll see why disability is going to be the focus of our work today, because it is the single greatest discrimination basis annually, consistently, and we've only seen that number go up year after year. Most of the complaints also involve rental transactions, and it usually falls within the areas of discriminatory terms and conditions, failure to make a reasonable accommodation, and then also refusing to rent. Beyond these statistics, I want to also make you aware of additional statistics impacting a very specific subset population of people with disabilities. HUD released a study in August 2017. It was the rental housing discrimination on the basis of mental disabilities. And essentially, it was a pilot testing program that evaluated how people with mental illness, intellectual disabilities were being treated in seeking and inquiring about housing. And the results of that study really showed that they were more likely to be told that a unit was not available. They were less likely to actually see a unit or to be shown the unit that's available. And also that they were steered and not provided with reasonable accommodations when looking for housing. So we know this is a problem. And so reasonable accommodations, when used effectively, can actually be a really good solution to keep somebody in housing that they may not be otherwise able to live in. So we look at this as really a tool, an effective and underutilized tool in terms of accommodations and making sure that people with disabilities get access to housing. It's a critical part of our agency's mission and a lot of the work that our partners on this call are doing. So when we're talking about fair housing laws, most people are thinking about the Fair Housing Act, but I really want to bring to your attention that there are actually many different laws and rules that apply to housing transactions that protect consumers and that providers have responsibilities for. The largest being the Fair Housing Act. That's the federal Fair Housing Law, Title 8 of the Civil Rights Act of 1968. It was amended in 1988 where it stands today, and we'll discuss because it's the broad act that most of these issues fall under, we're going to be spending most of our time looking at this law. But I want to make sure that you certainly understand there's additional laws that may apply depending on different scenarios. Architectural Barriers Act, that's going to cover post offices, Social Security, federal courthouses, federally funded buildings. So you think about your local government offices, they may have some requirements related to fair housing. The Section 504 of the Rehabilitation Act is certainly going to apply for HUD-funded properties. Americans with Disabilities Act applies to all services, programs, and activities. And then there's additional laws outside of federal laws. We have the Pennsylvania Human Relations Act, which we'll talk about briefly, that basically expands the protections at the local level beyond what the federal law provides. And then there may be some local fair housing ordinances or city codes that you have to be mindful of as well. So again, I say it's very complicated to kind of untangle which laws apply, and it would you'd have to kind of evaluate all of these to see, based on a specific scenario, what you may have to keep in mind. So for the Federal Fair Housing Act, and just very quickly, I want to make sure everybody has a basic understanding of what the Fair Housing Act says. It makes it unlawful to discriminate against these groups of people that are on the slide here. They're called the protected classes. It's illegal to discriminate in a housing-related transaction based on disability, race, sex, color, national origin, religion, and family status. Family status refers to specifically having children under the age of 18 within a household, or somebody who is pregnant or in the process of adopting a child. So they're all covered within these protected classes under the Federal Fair Housing Act. The Pennsylvania Fair Housing laws then expand those protections kind of even further within protected classes. They will then make it any housing-related transaction would then also be covered under fair housing if it's over the age of 40, so 40 and over cannot be denied housing or discriminated against. The use very specifically of a guide or support animal is written out into Pennsylvania Human Relations Act. And then also the disability of an individual with whom the person is known to have a relationship or association, and pregnancy and ancestry. So it's important to kind of know that there's additional protections based on fair housing laws within the state. And there may be additional local protections within your ordinances and communities. There's a lot of protections based on marital status, sexual orientation, gender identity within a number of local human relations commissions. So it's important to really understand which laws are applying depending on the location where a transaction may be taking place. Very specifically, and I'm going back to the Federal Fair Housing Act that says what is against the law within fair housing. It's illegal to refuse to rent housing to somebody based on those protected classes. It's illegal to make housing unavailable, deny it's available, setting different terms, conditions, or privileges for one protected class, and making sure that a protected class is kind of excluded or treated differently would be discrimination under the Federal Fair Housing Act. Discriminatory advertising is not allowed, and threatening, coercing, or intimidating anyone who is exercising their rights or assisting others with those rights. That's an important piece because for filing a discrimination complaint or alleging that discrimination has occurred, you cannot be treated differently for simply going through that motion of exercising your rights. There's also expanded protections within the regulations for to ensure that new construction housing is designed with really some basic visitability features, and that there's extensive details on design and construction requirements available. So that's important to know that that's an additional expanded protection that helps create more accessible housing for people with disabilities. And then it also provides the reasonable accommodation and reasonable modifications within housing for people with disabilities. Today we'll be focusing on accommodations. Those are really the changes to rules, policies, and practices. But modifications are actual changes to the physical structure of a building. So I typically, when I think through what's an accommodation, what's a modification, modifications, rules, policies, practices, modifications usually involve money that involves changing some sort of physical feature within a unit, whether it be installing grab bars, a ramp into a unit, things that would allow for somebody with a disability to physically access and utilize a space fully. So there's a couple exceptions to that, but for the most part, accommodations are really just going to focus on rules, policies within housing. It covers most all properties. I want to be very clear. I kind of throw this slide in so everybody understands that it's going to apply to homeless shelters, nursing homes, private housing, public housings, apartments, and condos. There are a few exceptions that I'll explain in a little more detail, but on its whole, it's fairly broad in terms of the types of housing that is covered under fair housing. And again, with transactions as well, it applies to rental sales. We see most of the issues within the rental sphere, but lending practices also fall, appraisals of homes, zoning and land use decisions also must comply within fair housing rules. And then homeowners insurance. You can't purchase a home unless you can get access to homeowners insurance. So these are all important transactions where fair housing laws would apply, and accommodations can be requested within any of these transactions or covered properties. I did mention I was going to say a few things about exemptions under the Act. There are some narrow exceptions that you have to keep in mind when looking at fair housing issues. Owner-occupied units with 4 or less rental units are they're called Mrs. Murphy's exemption. So it's basically it's designed so that no more than 4 families living independently of each other within the same space. I do want to mention that this is certainly Pennsylvania Human Relations Commission applies a narrower restriction of this type of exemption to personal residences. It defines it as a building or structure containing living quarters intended to be occupied by no more than 2 individuals. So again, under the state law, there may be expanded protections that go beyond the exemptions at the federal level. For sale by owner is another situation where there's exemptions built in some areas of fair housing. Religious organizations can rent units or homes that they have to members within their organization. That applies. You think about a church that has a property. They can, certainly rent that within their church as long as the religious organization does not discriminate on the basis of race in terms of being a member within that community. There's also, I think, the most common exemption people understand and does confuse fair housing is housing for older persons that can restrict occupancy and keep children out if they follow and qualify as housing for older persons. So 100% of occupants 62 or older, or 80% with at least 55 and older, and they have to follow very specific restrictions to have that. There are also no exemptions for discriminatory statements or advertising. So this was my very quick, over-the-top, you have a good baseline knowledge to kind of build from now, and we're going to move kind of quickly into the disability aspect of looking at accommodations. The definition itself under fair housing laws was designed to be as broad as you're seeing it here. And this is the very specific definition of a physical or mental impairment that substantially limits one or more of a person's major life activities. I've included some examples here: breathing, hearing, walking, seeing. And I do think it's important to note this includes people who have a history of an impairment or somebody that's perceived as having an impairment. So it's important to understand it's very broad. It differs from maybe some of the other federal definitions that you may see with other programs you're working with. This is the definition that is for the Federal Fair Housing Act. And the definition is really important to know because it decides whether an accommodation or modification is permissible. You can't request an accommodation unless you meet the definition of a disability under the Fair Housing Act. Reasonable accommodations, as I said earlier, is a change in a rules, policy, practice, or service when the accommodation may be necessary to provide an equal opportunity for a person with disability to enjoy their dwelling. There has to be a connection between the disability and the accommodations. And I think it's important to note that this accommodation request doesn't have to be in writing. We certainly as advocates always recommend that, but it isn't necessary for an accommodation request to be made. Most tenants are unaware of their rights to request an accommodation, and it may be as simple as asking a maintenance person for help with something. If it's identified as being connected in with their disability, it could be as simple as that. They don't have to use exact language of saying, this is an accommodation request as protected under my rights of the Federal Fair Housing Act. I think most consumers understand, and providers need to have an understanding that there's some flexibility built into this to make it reasonable. These accommodation requests can really be made at any time within a process. It could be during the application process, while they are living in a unit, anytime a housing provider kind of changes a rule or policy, or in response to their action. It could be through an informal hearing, an eviction hearing. There's lots of different places where an accommodation may be appropriate. I've included an example, some of the more common examples that I've seen over the years of accommodations that have been requested, and I write them out here as accommodations that they could be reasonable depending on the facts and scenarios, but they could also be unreasonable. If somebody who doesn't have a disability requests this, they wouldn't be entitled to it, and so it wouldn't be a reasonable request. So I like to keep this kind of open that some scenarios it may be reasonable, others it may not. It really does depend on the facts, the individual person's needs, and the provider situation. So providing notices and leases in large font, that's usually a standard and very easy request that has been made. Mailing or allowing someone else to pick up a housing application where maybe they can't get physical access to somewhere. Issuing monthly reminders, that has been requested and granted as reasonable in some limited scenarios. I actually find landlords are very agreeable to this because if it means they're getting their money, then they're very open to just sending a quick text once a month to remind somebody who maybe needs that added level. And again, it's a conversation you try to come up with what works best for the consumer. Permitting a live-in aid, personal care attendant. I was involved in a case involving keys, making sure that there was keys granted for that live-in aid personal care attendant so they could get in. The community had a policy of no more than 2 keys, and they made a very good case for why they needed that additional key related to their disability. Allowing termination of a lease without penalty, that particularly comes up when somebody's transitioning to nursing home, and we've been very successful in creating those types of accommodation requests. Allowing transfer to a more accessible unit, again, if it's within a community where you could move to a different location that would allow you to stay within that community and it's available and reasonable and appropriate, then that's certainly an accommodation that would fall as reasonable under the Act. Tenant notification, if they're using certain cleaning chemical sprays that would interact with the person's disability, or accepting an alternate reference from an applicant's employer or social worker in lieu of kind of the traditional housing references. So we do find with a lot of the populations we work with, they may have no rental history, which is oftentimes held against them as they go out and searching for housing. So in those scenarios, we have been able to request that they accept a different letter to use in terms of the application process. So the challenge with reasonable accommodations is really coming to a determination of if a request is reasonable or not. And that is usually where it gets a little more complicated. Very specifically under the Federal Fair Housing Act, the guidance tells us that it is reasonable if it doesn't cause an undue financial and administrative burden. It can't cause a basic change to the nature of housing. It can't cause harm or damage to others, and it actually has to be technologically possible. I received a call from a landlord once who it was requested that they install a lift into the building, and it was technologically impossible based on the structure, and it was something the landlord wanted to entertain, understood that they had an obligation to respond to and try to come up with solutions, but it was not a reasonable request. So that's kind of a scenario. And I do like to talk about, in terms of changing the nature of housing, one of the requests that I kind of go back to for an example is somebody asking that a landlord provide them with meals 3 times a day. And this is, I think back when I was renting, that would have been fantastic, but completely unreasonable if, for a private landlord to do, because it would change the basic nature of the housing that they provided. However, within the circumstances of an assisted living community that provides meals within a location for its residents, it may be reasonable to ask that they provide them maybe in a different location that somebody with a disability would then be able to use that service. Because that was the nature of the housing that they provided, it could be shown as a reasonable request. So I do like to kind of keep these things in mind as you're sorting through what would be appropriate. I think we're all very familiar with kind of HIPAA confidentiality protections, and fair housing is very sensitive to this, understanding that the consumers who have disabilities that want to live in housing, and they don't necessarily need to share very specific and detailed information about their disability that is not relevant to what the provider needs to evaluate if a request is reasonable or not. So I've included here that, a provider can't ask the type of disability, nature or severity of a disability, anything that would waive somebody's rights to confidentiality or to see a prospective tenant's medical records. So just keeping that in mind, we are going to talk about some areas where a landlord can request additional information on a person's disability to make sure, to confirm that, one, they do have a disability and that they are covered under the Act, and that there's a connection between the request for the disability and the accommodations they are asking for. A few groups that I just want to highlight within the regulations are not entitled to reasonable accommodations. Juvenile offenders, sex offenders, they are not, based on their status alone, entitled to reasonable accommodations under the Act. Same thing with anybody who is currently engaged in illegal drug use. And then also individuals where their tenancy would constitute a direct threat. However, I do like to add a caveat to that there certainly are cases where reasonable accommodations to rules or policies may create an environment where the threat has been either eliminated or significantly reduced by an accommodation. An example that I often give is somebody who has had maybe something on their criminal record in the past, or an issue related to housing, and they were off their meds at the time. They now have consistent support within their community, and they can make a solid case for why they are not going to have the same issues that prevent them from living in housing now. Persons who are recovering from substance abuse are certainly protected under the Fair Housing Act, but not those with a history of drug dealing or manufacturing. In terms of verifying the disability and the need for the accommodations, it usually falls into one of these three categories. If disability is obvious, the need is clear, no additional documentation. So this is somebody who comes into a community and they have very clearly a visual impairment. They have a guide dog with them. There is no additional documentation that they would need to provide to show the connection between their disability and need and their request to allow an assistance animal within a no pets, when there's a no pets rule within a community. However, if the disability is known but the need is not really clear, then the provider should only be requesting information really necessary to evaluate the disability-related need. So there really has to be an explanation then really solely focused on the relationship between the disability and the need for the accommodation. Now, if the disability and the need are both not known, the landlord can request for verification from a medical professional, professional service provider, peer support group, or a reliable third party who knows about it and can kind of explain what is the where are the disability-related needs for this consumer. So one of them that I would run into is a tenant has respiratory problems and it requires a transfer because of a neighbor's because of smoke within a facility. So that may require, documentation of respiratory problems or effect of smoking. So again, keeping that in mind, there may be some areas in here where the landlord can engage in a process to get information in order for them to evaluate if the request is reasonable or not, and if the consumer qualifies for that accommodation. So the common mistakes that I say come up kind of regularly with these requests is a delay on the part of a landlord in responding. They have to respond to them. Failure to respond is essentially denying an accommodation request. So even if it's not reasonable, the landlord has an obligation to engage in an open dialogue communication with a consumer. Pressuring the requester into taking alternative accommodations, it really is the consumer is the expert of their fair housing needs and what they need related to their disability. So it's important, a landlord doesn't get to kind of counter offer with what they think would be helpful for the consumer. Again, they have to engage in a process and respond to the request that is asked of them. Housing providers that are very rigid in their process require forms they have to understand that, not everybody has to go through that process. And if you're denying somebody because they didn't go through your process, that certainly would expose them to risk as well. Making sure it's interactive, that they're engaging with the consumer. I've had landlords say, I need more time to consider this request. And that may be reasonable and understandable, but they need to be communicating with the consumer throughout the process. Another major problem is really training, making sure that people are trained on what the rights are and responsibilities for landlords. So again, making sure that a maintenance worker who receives a request, that they are providing an appropriate response that does not create risk for the housing provider. So that's really kind of the basics of reasonable accommodations. I'm going to get into a couple slides here on some hot topics that we get the most questions about. I saved assistance animals for the end because I know that's the one everybody likes to ask a lot of questions on. And very quickly, I kind of like to I think we're all very clear on the service animal definition under the Americans with Disabilities Act. It's important that you understand that assistance animals, which is a kind of broader definition that includes guide dogs, assistance animals, emotional therapy. They're all categorized as assistance animals under Fair Housing Act. And the idea is being that when you're in a public space where ADA would apply, if you're traveling on planes, there may be the need for more restrictive requirements that would only provide those protections and services for somebody that has a service animal as defined under ADA. Assistance animals, you're in your home. It's a much different environment, and so they recognize that there's lots of benefits that other animals could provide. So making sure that emotional service assistance animals, they're all considered assistance animals under the Fair Housing Act. With assistance animals, landlords can't deny a person the right to have an assistance animal or evict because they've asked for one. They can't charge extra fees or deposits. This is the one I see the most issues with, where it's a $35 a month for a pet fee, which they can do for pets, but they cannot do that for an assistance animal that is helping a person with a disability-related need. You can't stall or delay on responding to a request. They can't deny an assistance animal due to allergies, fears, or other tenants' residence. There's some good case law, particularly on this one, related to the Philadelphian in Pennsylvania. They had significant concerns involving allergies, fears, tenant harassment, and it's a good case to kind of look at in terms of any communities that might be thinking that they need to balance different needs within a community. It's also important they can't dictate the type, size, or breed of assistance animals, so there may be some kind of local protections and zoning issues, particularly if you're looking at exotic breeds that may be covered as an assistance animal under the Act. Now, I talk about what landlords and providers can't do. I do want to kind of balance this out with what they can do and they can require under the Act, which is that there's reasonable rules for cleanup, noise, and control. They can hold a tenant liable for damage. They can't anticipate that in advance and ask for those damages in advance. They do have to do them after damage has been caused. They can't exclude support animals that may cause physical damage where you could kind of reduce or eliminate that with a reasonable accommodation. And they can exclude support animals that are a direct threat to others. So that's but it really has to be based on credible information. I think kind of these blanket breed restrictions for pit bulls, I understand that it's really not the dog, it's the owner, it's not the breed, it's the people with them. There's a lot of good large breed dogs that, you know, a little poodle is not going to help somebody stand up. They need a large dog for that. So understanding that, you know, there are areas where it really has to be justified based on, you know, important information that is based in facts and reality. The other area I like to highlight, because this is also a hot topic and there are accommodation solutions for it, is when it involves somebody with a criminal background check. Someone with a criminal history can request an accommodation if their crime was a result of a disability or tied in with their disability. They can always still reject somebody who poses a direct threat to the health or safety of others. But again, we think this is an underutilized tool for circumventing criminal background checks within housing. It really has to be considered based on reliable, objective evidence, you know, not really fear, speculation, or a stereotype. They have to be looking at the current conduct and recent history of disruptive behavior, and looking also at the nature, duration, and severity of a specific act. So it's important that, you know this is a tool that you could use to request an accommodation if it does seem to kind of line up with all the other accommodation areas we've discussed so far. Housing providers really have to prove that the policy has concrete reason to exist. So they can have a criminal background policy, but it could also violate fair housing laws if it has a discriminatory impact on protected classes. There's 3 steps that you would have to take to kind of prove that, is that the demographics and incarceration statistics really show that it's going to disproportionately affect people in protected classes. The housing provider also has to prove that the policy has concrete reasons to exist, and if shown that that criminal history policy is necessary to achieve a non-discriminatory interest, are there less discriminatory alternatives? So it can get a little tricky. I recommend that if you're going down this path of kind of looking at discriminatory impact on various protected classes and challenging on kind of a broader goal, you really need to bring in some fairly seasoned and experienced fair housing attorneys to unpack all that information. So that's what I wanted to cover today. I'm going to leave you very quickly with some resources and assistance and explain, you know, what you can do if you see things in here where there have been violations, there's concerns. As an advocate, I know there's lots of different tools you can use to end discriminatory practices. Mediation, you know, I always like to exhaust that before you move on to kind of the other options. Testing is an area where you can evaluate and document if discrimination is occurring. HUD complaints through PHRC and HUD. I've included a slide with information how you can file a discrimination complaint. You could also look at filing a federal lawsuit, which would require either legal assistance or a private attorney. So HUD is the entity that handles all discrimination complaints, and this is a process where you could file with them. And then I've also included additional resources and information. Everything I talked about within here, if you see the HUD guidance that I've included on this slide, there's links within each of those where you can go and read. I mean, some of these documents are really detailed and involved, but I find they have a lot of good answers in there when you're trying to work through something. So I like to give these resources so you can kind of sort through what helps and what doesn't. PA Law Help, I got to give them a plug. They do great information resources out, and you can connect in with all your local legal assistants organizations to get additional help with fair housing. There's a design and construction checklist, anyone interested in the accessibility. And then Housing Equality Center of Pennsylvania has fairly extensive resources and topics that get into a lot more detail on everything I've covered today. So there's a lot of good resources that they have there. National Fair Housing Alliance is another great advocacy resource. They frequently have information. Their Pennsylvania Human Relations video has some videos that you can share with consumers. You can share with your staff as well. I really like there's a Know Your Rights as a Renter in PA guide that gets into not only fair housing issues, but also broader landlord-tenant. There's usually a lot of overlap. So this guide, I think, does a good job of kind of pulling it all together. And they also include some sample letters for accommodations. I also just want to very briefly highlight there's a number of fair housing enforcement and education agencies in the state of Pennsylvania that you can certainly connect with and ask for help and assistance with any of the issues you're facing or looking at within your community. So these are all great resources I kind of regularly direct people to, and I want to make sure you have that so it's a good understanding of what we can do and what we have available within Pennsylvania to assist. And that's what I had to cover for today. I know this was a lot. I'm seeing that there are some really good questions that I'm going to take just a moment to kind of catch my breath, take a sip, read through, and then respond to. Give me just one moment.
Thank you, Megan. As you said, that was a ton of really, really great information. So I think we have had some questions typed in over the course of the presentation. So how about I read those off and then you answer them?
Perfect.
All right. So our first question comes from Amanda. She asked, what qualifies a place as housing for older persons? Do they have to be agency run or meet certain state regulations? I guess I'm just concerned about someone claiming they are an older person rental place and how they would be providing proof of that.
That's an excellent question, Amanda. I think I have seen that firsthand where providers, mom and pop landlords say, oh, I'm housing for older persons. And they are not. You actually have to go through a fairly extensive process to qualify as housing for older persons. And they're one of the documents, Housing for Older Persons guidance from HUD, really clearly outlines how they have to document that they meet the exception. There's certain rules and regulations they have to follow in order to keep the exception. So it's not something somebody can kind of wade into without really understanding how they're doing it. So I would say on a whole, it's very unlikely that a small-time landlord would be that. You're looking at communities that have established this. They have gone through the process of documenting and tracking, the ages of people within a community, and that they make sure they have a way of quantifying if they're meeting that exception at any time. So I would direct Amanda and anyone else who's interested in this information. There's a HUD memo. You could search, HUD memo, housing for older persons, and it's a detailed question and answer on exactly how somebody would go about doing that, and that will tell you who does and who does not qualify.
Question comes from James. He has asked, who pays for reasonable accommodations?
Great question. So I think so accommodations are really changes to rules, policies, practices. There should be no cost associated with it. It's really just a landlord changing the way they're doing things. Modifications, on the other hand, that's usually where there's a cost involved. I will add this caveat. The only accommodation where there is kind of a cost involved that the courts and case law have decided is so nominal that it is not the part of the consumer to pay for is in kind of requesting a marked handicap parking space within a community. So this, the signage and the paint that's determined, if that's something they provide regularly, that's a reasonable cost that the provider would have to carry. However, so that's the only kind of area within an accommodation where there could possibly be a change to a rule, policy, or practice that then the provider has a cost associated with it. The modifications are different. That is where there usually is a cost involved for installing grab bars and making modifications. And I will share, that with those modifications, in most cases, it is the responsibility of the tenant to pay, or the consumer to pay for those modifications. The landlord has to permit it and allow it, but it would be the responsibility of the tenant. Where it would be the responsibility of the provider is if it is HUD-funded, project-based housing, so not Section 8, but in a property that is owned and operated by a HUD-funded provider. So you think about kind of your public housing that is run by the government, where people come in and out of that unit. That would be the responsibility of the provider to pay for that modification if it's reasonable.
What about project-based vouchers, right? Like the voucher is attached to the unit and not the tenant. Is it still the tenant's responsibility?
This breaks my heart because I have to tell you this, but no, it is the responsibility of the tenant to pay for those modifications. And I would recommend there are, limited sources of funding available for those types of modifications, but in terms of a voucher recipient who's going out to the private market looking for housing, if they need a modification, they would have to pay for that. I will say I've found some landlords that are very open to sometimes paying for it if we can kind of convince them as advocates that, having this type of housing is actually a marketable feature to include and use in the future. So I would say as advocates, you could always ask for and try to help promote creating more accessible housing features within the private housing market.
Great. Our next question comes from Jessica. HUD allows specific funding for youth-designated programs. To designate programs for transition-aged youth ages 18 to 24, because this is allowed by HUD, how do we make sure this isn't discriminatory?
So in terms of when I discussed the protected classes, age was not a protected class at the federal level. So unfortunately, I've had young adults call in saying they're being discriminated, treated differently because of their age, and there really isn't a protection for young adults at the federal or the state level. Remember, the state level expands the age protections, but only for age 40 and over. So say somebody's 60, they're out looking for a 30-year mortgage, and they're denied because of their age. That would be discrimination based under the Pennsylvania law that covers people age 40 and over. That consumer could, in theory, also, if the consumer was 19 or 20 and told they can't get a 30-year mortgage because of their age, there actually really isn't any protection at the state or federal level. So I do think in terms of designating programs for transitional age youth, and I will say 18 to 24, there's a lot of need for that type of housing. There's very few available. So I would look to the current protected classes and make sure that nothing that you do would impact, or appear to provide a preference, based on any of the protected classes at the state or federal level.
Okay. Next question is from Jessica as well. I have seen a number of programs that are targeted towards LGBTQ youth. How do we make sure these aren't discriminatory since they are targeted to serve a protected class?
So I would broaden that question, take the youth out of that. If it's targeting towards youth versus targeted towards LGBT, there are a number of kind of senior housing LGBT communities that they have to be very clear and walk a fine line of not discriminating and excluding people who are not LGBT. And so HUD has provided guidance on this in the past that, they have to be very clear in how they're marketing that it's for everyone, but they do it in a way that promotes an environment where LGBT youth and adults would feel welcomed and secure. So that's been kind of a fine balance that some of these communities have been able to manage. But again, I think HUD recognizes the critical need for these types of housing, and that's why they produced guidance. So I would recommend if you search with HUD LGBT, and if she can't find it, you can reach out to me, and I'll be sure to dig around and get that information for you.
All right. Our next question is from Deborah. Do you know of any reasonable accommodations for a sex offender who is confined to a wheelchair?
So the question, it really depends. Honestly, the accommodation really is it a reasonable accommodation related to access into a community, or is it a reasonable accommodation where the sex offender status is what's keeping them, from getting into housing? I don't think I have enough information to really determine, so if we say there's certainly reasonable accommodations for somebody who's confined to a wheelchair. I think, one of the areas where there may not be a reasonable accommodation is if somebody has a sex offender status, and that again was something that was excluded from the accommodations, provision.
Great. We have our next question is, I have a property that is a 2028, and a resident of mine, when she moved in, required features of a handicapped mobile accessible unit. But now that she turned 62, she wants to move to a non-mobility, non-handicapped unit. Nothing has changed as far as her needs go, but would she be eligible for a non-mobility accessible unit, considering she stated she needed one when she moved into the property?
That is an interesting, this is the thing I love about fair housing. I get a new question I've never heard, every single training. And this is unique in that somebody has requested the accommodation, there's a need, and they're now want to move to a unit that doesn't have those features. So the move to the unit, I think they would have, just as with any other unit change where they're moving from one unit to another, if there isn't kind of a process where somebody could regularly do that within a community, which I'm assuming there isn't here. But in the case where somebody would be moving and there's a disability-related need, they'd have to certainly provide the basis for why that is needed. I'm not sure that there would be that in this scenario, since it isn't related to a disability. It's just somebody wanting to move from one unit to the other. So if you kind of take out the fact that her old unit is an accessible unit and just view this as a tenant who wants to move from one unit to another, I think you may be able to think about that a different way. And I would encourage, I think the other piece of this is you have to, and I did note that this is different funding sources, 202 and a 202 residency. They may have different rules, regulations under your HUD funding. So I would encourage you kind of look through all of those to see if there may be a solution. And this scenario does perfectly highlight how sometimes these requests can make your head spin. It doesn't there's not always a simple, easy solution, and you really have to pick apart exactly what is at play and what are the options. But I would say the first step would be make sure you're engaging and documenting how you are responding to any of these requests, so that if at any point you had to then show what you were doing, you always have a track record of the efforts you're undertaking.
Great. So I think we have time for one more question, and it looks like Becky is asking, is there a standard RA form, and can each private landlord create their own and require completion of it?
So I have seen there is no standard reasonable accommodation form. There are some communities and certainly large housing providers that in order to help them respond to it, they've created kind of their internal reasonable accommodations form so that they can monitor and follow a process. My comment for that is that they can create it. They can't require completion of it. You know, they can't say we're only going to provide you with this accommodation if you complete our form. There is nothing within the Fair Housing Law that says in order to get an accommodation, you have to complete the form. There is none of that. It's meant to be an engaging process where you're communicating with the provider. It doesn't even have to be in writing. You know, it can be a verbal request. I would say that some communities have done accommodation forms, and that's good if it helps them with compliance, but they need to be flexible with it. Sometimes once they have the form, they're kind of stuck in the mindset of it has to always go through the form, and that is not the way the rules work.
Right. And what about for the smaller private market landlords that is just like you didn't complete the form, so I can't accommodate it? I mean, to me, it might seem like this could be an additional barrier, whatever the accommodation may be, you know?
For sure, and also it could delay. You know, if there's, if somebody comes in like that person where the disability need is clear, the disability is clear and the need is obvious, asking for the form is an unnecessary delay. They know it. They should provide the accommodation if it's obviously reasonable. So again, I would push back. I'm a strong advocate, so I kind of always push back on those, but I think every consumer, has to kind of evaluate the best approach. But I would say on a whole, there's room to challenge those types of processes and also to help educate housing providers to help them understand so they can operate their businesses, more effectively.
All right. And then we have one last comment to ask for some clarification, and then we're going to have to finish. But it's amazing that folks have hung in this long. I wanted to clarify something very quickly. If a renter requests modifications to their apartment for their own disability or the disability of someone not on the lease living with them, whose responsibility is it to pay for the modification?
So the person who requires the modification isn't on the lease or living in a unit. I would say that's a concern under landlord-tenant. So, the person who's requesting, I would, without kind of having the very specifics of why a person is living with them who's not. So say it's somebody that has custody of a child, a couple days. I would think they would still be on the lease, though. I'm trying to think of a scenario where they wouldn't be on the lease. It's ultimately, at the end of the day, if a landlord were to permit that modification, it would be the responsibility of the household, the tenant in that transaction, that landlord-tenant transaction, to pay for the modification as long as it's not a HUD-funded source within the confines of what we discussed earlier, where it's project-based housing. And I think, the piece of this, if it's for their own disability and a renter requests modifications, kind of taking out the piece of if it's somebody that is on the lease, it is their responsibility to pay for the modifications. The landlord just can't block it. And there are some reasonable steps. There's a fairly lengthy memo, just as there is for accommodations, on modifications, on, when they could ask for money being put in escrow to return it to its original condition, when they can't do that, if it benefits future tenants, and just kind of the process they have to engage in. They can require it be done in a workmanlike manner. So that's another area you have to kind of follow very closely on the best way to do it. But I would say in most circumstances, it is going to be the responsibility of the tenant to pay for that modification.
Excellent. Excellent. We are right at 1 o'clock. I want to say thank you to Megan for this great presentation and wealth of information she shared with us. To everybody on the phone or online, and to all of the great questions. We do ask that you fill out a brief survey after you sign off of the webinar today to let us know what you thought about today's presentation, if you want to share ideas for future topics, if there's maybe one point in this topic that you want us to take a deeper dive in, just let us know what you think. And with that, I'm going to wish everyone a wonderful afternoon, and we will see you at the next webinar.